You can all hear me, sure. I imagine. And let me just see if this, okay, great. So ever since the leak of the US Supreme Court opinion in Dobbs on May 2nd, all I've been doing is thinking, speaking, and writing about abortion. So when I was invited, when Karim invited me to this conference on new developments in the accommodation of religious law in modern states, I was thrilled to participate, not just because it gave me the chance to come here to Haifa, where I've never been, and to meet all of you, but also because it gave me the opportunity, the perfect opportunity, to write a paper on abortion and religion. And it has become crystal clear to me that the Dobbs opinion and abortion this past term, that it is intimately connected to religion. In fact, Linda Greenhouse, who many of you may read, recently wrote an op-ed this summer where she talked about categorizing the cases each Supreme Court term. She's a Pulitzer Prize-winning journalist who writes about the Supreme Court. And she said that she initially categorized Dobbs as an abortion case. And then when the term wrapped up and she was putting away her charts, she realized that she had miscategorized Dobbs, that Dobbs belonged not in the section on abortion, but that it actually belonged with the other big religion cases of the last Supreme Court term, the US Supreme Court term. One involved a praying football coach who wanted to engage in Christian prayer on the football field, and another involved subsidies, required the state of Maine to provide subsidies for parochial Catholic school tuition. So I titled my paper, very provocatively, America's Abortion Theocracy. And what do I mean by this? Michael actually, the other day, was challenging me on the use of the word theocracy. And so I'm using it very broadly and generally to suggest that although the US purports to be a secular, religiously plural nation that embraces a, quote, wall of separation between government and religion, close examination of American abortion law actually reveals the US to be, I guess you could say, a democratic theocracy. Michael was pushing on a democracy couldn't be a theocracy. And so I'm saying a democratic theocracy, and by that, I mean a regime that enshrines the contested views of a particular sect of Christianity, predominantly white evangelicals, into law. So let me proceed here. A very brief survey of the approaches of a number of major religions. Ooh, did I lose that?
Yeah. I did.
Okay, so, while I wait for the PowerPoint to appear again, what I'm going to do is to give you a brief sketch of the approaches of the major world religions to the question of when life begins and the morality of abortion. And technical difficulties here. And what this shows you, or what it will show you, is that essentially, there it is, the beginning of life across different religions. It's pretty much Christianity that draws the line at conception of when life begins. Islam says that ensoulment doesn't occur until roughly 4 months, 120 days. And Buddhism says that it's the moment of consciousness at which ensoulment occurs. And consciousness doesn't occur until until there's a manifestation of physical sensation. So, can I get this to advance? How do I make it go forward? Can I do it this way? Okay, there. So how do we have to do it? Okay, thank you. Okay, I'll use that. Okay. There it is. So when does life begin? At conception according to Christianity, at 120 days according to Islam, at approximately 16 to 21 weeks according to Buddhism, when consciousness becomes manifest through movement. Hinduism says not until 7 months when consciousness happens, and Judaism says at birth. Of course, here I am in Israel, and so maybe you will contradict me, but this at least is the claim of one prominent synagogue in a lawsuit, which I'll talk about later. So if you track the timeline of pregnancy with these various religious views, you can see that the idea that life begins at conception, or even prior to 15 weeks, really coincides with Christianity, not with many of the other major world religions. And if you do a survey, this is the Pew survey, very famous survey in the United States, of religious attitudes in the United States towards abortion. Basically, it's the white evangelicals who are most opposed. White evangelicals over here, 74% of whom think abortion should be illegal in all or most cases. Catholics, it's only 47%, as opposed to 48% think that it should be legal in all or most cases. So the Catholics are divided roughly 50-50, but it's the white evangelicals. The Protestants, white Protestants, not evangelicals, 60% of them think that abortion should be permitted. Black Protestants, it's even greater. It's 66%. And then Jews are, besides the unaffiliated, largely secular groups, the Jewish population, 83% of whom in the United States believe abortion should be legal. Buddhists fall just behind at 82%. So the United States is a religiously plural nation that encompasses all of these different groups. And I'm having trouble with this again. Okay. There it is. But if you look to the next slide, although the U.S. is a religiously plural nation that encompasses all of these different groups, if you look at our state abortion laws, they pretty much track the views of this one particular sect, the Christians. We've got 15 states over here that draw the line at conception, another 6 states that draw the line at 6 weeks after the last menstrual period. And so a huge number of states have enacted abortion laws that are out of touch with the general population of the United States, with most other religious segments of the United States, and which really track the views of one particular group, the white evangelicals and the Christians. And this, of course, so here it is. Even though the U.S. is a secular, religiously plural nation, these laws track one particular group. And moreover, many of the laws themselves actually were drafted. They're taken, the text of those laws, from model statutes that are enacted by the National Right to Life Committee, a lobbying organization that is, that has kind of technically separated itself from the Christian Catholic Church, but is closely linked to that. So they've got religious origins. And what Professor Ram Rivlin suggested earlier was that a religious norm becomes, quote, religious due to its origin. Can we then say that if these state abortion laws are lifted from texts that are drafted by religious lobbies, that they are religious in origin? That, at least, is my contention. What about Dobbs? the Dobbs opinion, which was drafted by Justice Alito itself, has created such fury across the United States. And here, you've got to pardon me if I'm not exactly unbiased, because I clerked for Justice Harry Blackmun, who was the author of Roe versus Wade. And Dobbs really, not only does it overturn Roe versus Wade, but it does so in the most gratuitously insulting fashion, skewering Roe's logic and ridiculing its reasoning, and suggesting really, lampooning it and mocking it in a way that seems profoundly disrespectful of precedent, and of all of the justices that over the years have signed on to that precedent, which became part of the U.S.'s constitutional culture, and which has existed for almost the last 50 years. So what does the draft opinion do? Well, it skewers Roe and the reasoning behind it. But what does it hold? It actually holds that Roe and Casey, not only that they must be overruled, but that the Constitution contains no right to an abortion because it's not deeply rooted in the nation's history and tradition. Of course, that exact same logic also applies to many other rights that are not deeply rooted in the nation's history and tradition, including, most recently, the right to same-sex marriage. So I want to keep track of the time. Dobbs, of course, returns the issue of abortion to the states. What does this portend for the future? Well, on the chopping block are not just laws relating to contraception and marriage, and even to intimate sexual activity. So this is what the United States looks like now after Roe versus Wade has been overturned. That we've got these career laws across the United States, and here's the makeup of the U.S. Supreme Court that decided the Dobbs opinion. So circled in red are the 5 justices in the Dobbs majority opinion. Note that 4 out of 5 of those justices, Alito, Thomas, Kavanaugh, and Amy Coney Barrett, are all Catholics. The only one who isn't is Neil Gorsuch, and he's an Episcopalian but was raised as a Catholic. Roberts, who I've got in purple because he concurred in the result in Dobbs, is also a Catholic. And then the 3 dissenters, 2 of whom were Jewish, Breyer and Kagan, and then Sonia Sotomayor is also a Catholic. So we have an unprecedented Supreme Court with a majority of Catholic justices. Here's the religious composition of the Supreme Court. But it goes even further than that. The court is not only dominated by Catholics, but Justice Alito, the author of the Dobbs draft opinion, just a month ago, spoke at a religious liberty summit that was organized by Notre Dame Law School in Rome. And in his speech, here's what he said. He said, the problem that looms is not just indifference to religion, it's not just ignorance about religion, there's also growing hostility to religion, or at least the traditional religious beliefs that are contrary to the new moral code that is ascendant in some sectors. The challenge for those who want to protect religious liberty in the US, Europe, and other similar places is to convince people who are not religious that religious liberty is worth special protection. And he says freedom of worship means freedom to do those things that you like to do in the privacy of your home or in your church or synagogue, mosque or temple. But when you step outside into the public square in the light of day, you would better behave yourself like a good secular citizen. That's the problem that we face. So you can see that clearly part of his agenda is bringing religion out into the public square, and that Dobbs is very much a part of that agenda. These are excerpts from Justice Alito's speech in Rome. Okay. Let's try it this way. But even more controversially and provocatively, Rolling Stone magazine reported this summer that caught on a hot mic was this evangelical minister, Peggy Nienaber, who claims that she, quote, prayed with Supreme Court justices. And the justices then cited an amicus brief that was filed by the umbrella organization that her ministry is a part of, Liberty Counsel. So all of this looks incredibly unseemly, right? This kind of intermingling of church and state. But is it unconstitutional? And that brings me to the close to the end of my presentation. A synagogue, a Reformed synagogue, a congregation in Florida, has recently brought a lawsuit challenging Florida's abortion law. Rabbi Barry Silver filed this lawsuit on behalf of his congregation, Lador Vador, alleging that the Florida abortion law violates religious freedom, among other claims. And this is based upon the grounds that Judaism not only permits abortion, but that it even requires abortion in certain circumstances, such as when the woman's life is at risk. And that Florida's law in prohibiting abortion under these circumstances is infringing upon the religious freedom of dissenters, of people of other faiths who would like to follow the dictates of their own religion, but feel that they are being coerced by the majority, by the minority's imposition of its religious values, the Christian religious values, upon the rest of a religiously diverse country. And this is not just the argument made by this congregation. Clergy from 5 other religions have recently filed a lawsuit challenging Florida's abortion laws. And here we've got not just Jewish rabbis, but also a Unitarian Universalist minister, a Church of Christ reverend, an Episcopal priest, as well as a Buddhist lama. All of them are arguing that the Florida 15-week abortion ban curtails these clergy members' ability to counsel congregants about abortion in accordance with their faith. Because Florida law prohibits counseling or encouraging a person to commit a crime, and because abortion after 15 weeks is made a crime, they are arguing that their religious freedom and even their speech is being unconstitutionally restricted. Now, I don't actually think that these lawsuits are likely to prevail, but I think that what this raises are some very serious questions about how do we accommodate in a religiously plural and diverse nation that includes people of many different faiths, who have many different visions about the morality of abortion when life begins. How do you accommodate those values in a country that looks like it is becoming an abortion theocracy? So thank you.